right. Well, good afternoon, everyone. My name is Noali Perez. I'm the Associate Director of NAMI Santa Cruz. Thank you so much for joining us this evening. We are honored to have a very special guest, Ellen Cookman, with us tonight. Ellen Cookman is the Principal Attorney of Cookman Law in Palo Alto, California. She is passionate about helping families of all shapes and sizes plan for the future and utilize available resources. Ellen is a certified specialist in estate planning, trust, and probate law from the California State Bar Board of Legal Specialization. She received her JD from UC Berkeley School of Law and her LLM in estate planning, trust, and probate from Golden Gate University. Ellen lives in East Palo Alto with her husband, two cute and very active boys, Siberian Husky mix named Rosie, and a kitty named Skittles. Thank you so much, Ellen, for being here with us today.
Wonderful. Thanks so much. Thanks for having me. It's a pleasure to speak with all of you. Thanks for taking the time. So I'm going to share my screen and let's see how that goes. Okay, so hopefully you guys can see that okay.
Yes, we can. And I'm so sorry to interrupt, Ellen, but I just want to make one more announcement that if there are any questions, please feel free to put them in the chat and I will be reading those questions out loud. You can also use the raise hand feature on Zoom to raise your hand and ask a question. And many of the questions will be answered at the end, although Ellen will signal to the audience moments during her presentation where you are welcome to ask a question. Thank you, Ellen.
Oh, you bet. You bet. Yeah. Yeah, there are several times where we can pause for questions, but if you want to line them up in the chat, that's totally fine. I do ask that you ask questions that would be relevant to the entire group, not necessarily just specifically to your family. That's always helpful. You can always reach out to me separately for, really very nitpicky details. So I choose this cover page because I don't know if you guys have seen Down for Love. But it's a beautiful show set in New Zealand with kids with Down syndrome who want to go on dates, and so it's wonderful. Now we're going to be talking more about special needs with mental health challenges, but really our issue here is people who just haven't quite left the nest, where they still need some extra support, and that covers many different categories. Okay, so there we go. Okay, so that's the little introduction you heard. So when we're doing planning with somebody with special needs, really our goal is to maximize their quality of life. This is really what we want. Oh, and by the way, we'll send you the slides later, so you don't have to worry about taking notes, or you can just focus on it. So we want to maximize their quality of life. We also want to protect our children, sometimes from themselves, sometimes from financial predators, and we want them to be as independent as possible. But sometimes too much independence isn't a good thing. If they qualify for public benefits, we want to maximize those benefits. I understand some kids, of attendees here may not qualify for public benefits. It's a lot harder to qualify if your child has mental health challenges rather than developmental delays, for example. And what we're really doing is we're lining up surrogate parents, surrogate financial parents for when you're gone. Who's going to advocate for your child? Who's going to make sure that they have housing, that they're not out on the street? And finally, I might be a lawyer, but I hate going to court. I'm kind of a strange lawyer that way. And I hate fights, right? We want to avoid the court system if at all possible. Okay, so those are really the goals that we're looking at. Now, there are some public benefits that children who turn 18 can receive. Before age 18, typically your money is attributable to them, so they don't qualify. But once they turn 18, if they go through the process with Social Security Administration and they qualify as disabled, then they can qualify for these public benefits. So I'm just going to mention them just briefly. So the most restrictive one is called Supplemental Security Income, or SSI. And I say that it's restrictive because it has a resource limit of $2,000. That means your child can only have up to $2,000 in the bank in order to qualify for SSI. And if they qualify, they get just under $1,200 a month maximum. Now, It's really meant to supplement any other income stream they might be getting. So they might get less than $1,200 a month, but that's the most that they can get. And if they're making money, then that decreases how much they can get in SSI. And if they're getting another benefit like SSDI, which is the box below that, then that decreases it dollar for dollar. Now, if you get even $1 of SSI, you automatically qualify for Medi-Cal, which is California's version of the federal Medicaid system. And here is the big news. If you haven't heard it already, the resource limit for Medi-Cal has been eliminated. Okay, I want to pause for a second. Yes, I see one person going, what? Yeah, it's amazing. It over the last 2 years, the resource limit was increased. It used to be $2,000, just like SSI. And in every other state in the United States, it's still $2,000. But I think what California is trying to do is move to a Medi-Cal for all plan. So they're making it much easier to get Medi-Cal, and I am all on board. All right. So there's no resource limit. So you might think, oh, great, everybody gets Medi-Cal. Well, hold on. Now we have to look at the income limits. All right. So there is a limit for how much income you can receive. Earned plus unearned income, you can get about $1,670 a month. If you go over that amount, you can still get Medi-Cal, but you have to pay most of your income towards share of cost. Basically, you get to keep $600 a month of income, and then everything else has to be used first to pay your medical bills, which is onerous and draconian. So you want to keep under that income limit if you want to get Medi-Cal. All right. Then we also have Social Security disability income insurance, which any of us could qualify for that. If we become permanently disabled, we can get an income stream based on our earned income. The other one that's under that umbrella is CDB benefits. All right. And that's if somebody's parent, like you, retires and your child became disabled before age 22, then your child can get half of your retirement benefits at the same time that you are receiving your full retirement benefits. It's really great. And then when you die, the child gets 3/4 of your retirement benefits. And that one has no resource limit. And it's only effective if your child is able to work and earn about $1,500 a month. Okay, so that one's a really great one that a lot of people don't know about. And then and one really nice thing about getting SSDI or CDB benefits, which did I mention, it stands for Child Disability Benefits, right? If you get one of those after 2 years and about 5 months, you qualify for Medicare. So you don't have to be 65 in order to get Medicare. Okay, if you're getting SSDI or CDB, after a waiting period, you can qualify for Medicare. And we have some people who are receiving both Medi-Cal and Medicare. We call them Medi-Medi. And there's some people who are getting both SSI and SSDI. So it really depends where you fall. But here's the issue. Let's say your child receives an inheritance outright. And they're getting SSI. That's going to bump them off of their SSI, right? Because they'll have I hope they're receiving more than $2,000 of inheritance from you. So they won't get SSI anymore. So that can really interfere with things. Also, if they inherit something outright, remember we were talking about those financial predators? That can really interfere with that. So what do? Okay, we can set up something called a special needs trust. So a special needs trust is really an agreement between the parent setting up the trust, or grandparent, or someone else, okay, and the trustee, the person managing the trust, for the benefit of a disabled beneficiary. Now, to have a third-party special needs trust, which we're going to talk about in a second, you don't have to qualify as disabled. Okay, you don't have to be labeled by Social Security Administration. You can set up a special needs trust for somebody with mental health challenges who hasn't qualified for any of those public benefits that I listed on the last slide. Okay, but it's very protective for their lifetime. And if they qualify later, if you're appealing, by the way, if you got denied for SSI, try again. Half of the people who appeal after a denial get accepted. All right. And one nice thing about the special needs trust is it doesn't interfere with public benefits. You can keep getting your SSI, you can keep getting your Medi-Cal, because somebody else is managing the money. You set it up so someone else is the trustee. And because your child can't access the money directly, it doesn't count as their money. Even though there could be $1 million sitting there waiting to be used for them by the trustee's discretion. So it's really great. It really is meant to supplement any public benefits they might be receiving. And if they're not receiving any public benefits, then that's what they use to live on. So there's a third-party special needs trust, which is basically somebody is setting up a trust for the beneficiary, okay? And that somebody is putting money into the trust for the beneficiary. That somebody is a third party in relation to the child, the disabled child. So the disabled child can't put their own money in, but really anybody else can. And so this is the requirement for it. It's pretty straightforward, honestly. The beneficiary, as I mentioned, they can't act as trustee. They can't direct how the trust assets are supposed to be used. They can't terminate the trust. And then the trustee has sole discretion over how the money is supposed to be used. And then also the trust needs to be valid under California law if you have a California resident. So pretty straightforward, but there's a lot of bells and whistles that we put into the special needs trust to really make it very user-friendly. So I mentioned the third-party special needs trust. A first-party special needs trust is really the other one. If your child has their own money, maybe they inherit $100,000 from grandma, and they go, oh no, this is going to bump me off of SSI benefits, the child can turn around and put their own money into a first-party special needs trust. Nobody else can put money into the first, because the child is the first party. It's their own money. Okay, so it's really the source of the funds determines which type of trust you need. All right, now there's two main drawbacks with a first-party special needs trust. One of them is that you can only set it up for somebody before age, well, I'd say 3, before they turn 65. Okay, they can't put money into the trust after age 65. And then another one is that when they die, the government, Medi-Cal, wants their money back. So Medi-Cal can bring a reimbursement claim against a first-party special needs trust, all right? For any money that Medi-Cal has paid, really after the beneficiary was age 55 or up. And then also a first-party special needs trust can only be set up by the child themselves, a parent, a grandparent, or the court. So not just anybody can set up a first-party special needs trust. So, so I have a little diagram here that you guys can go back to, you know, when I send you the slides if you'd like, but it really compares, okay, what happens with a third-party special needs trust? Where does the money come from? You know, it's really anybody except the beneficiary themselves. In the trust, when we're drafting it, we say what happens to the money when the beneficiary dies. Okay, and you get to choose where you want it to go. But with a first-party special needs trust, Medi-Cal gets a reimbursement claim. All right, then there's also something called a pooled special needs trust. And this is really run by a nonprofit organization. And the idea is they pool together a lot of smaller trusts. And the nonprofit runs the trust, they act as trustee, they manage the money, and then you sign a joinder agreement. And this can be very helpful if somebody gets their own money and they're over age 65, for example, they can't set up a first-party special needs trust, they can set up a pooled trust. Okay, so now I want to talk about, I think, the hardest choice to make oftentimes when you're setting up a special needs trust. Who's going to be the successor trustee? Who's going to be the surrogate financial you? I mean, I'm sure that many of you, even by attending this, you know, many of you are you're advocates for your children. You're looking after them. You're providing everything that they could need. Who's going to take over that role when you're gone? So a lot of times we'll look at a family member or a friend. This is a big role for them. Acting as trustee is for a special needs trust is quite onerous, I think, because really you have to be trustee for the rest of the beneficiary's lifetime. And that could be another 50, 60, 70 years, right? It's not like acting as trustee of your own revocable trust when you get to just kind of wrap things up and get the money to the next generation, all right? The other problem is if you have a child with mental health challenges, a lot of times they might, it could develop a rift between your child and whoever's acting as trustee, because they could be resentful that somebody else is the gatekeeper to their money, especially if you have a neurotypical sibling. I usually suggest not naming that neurotypical sibling as trustee of your disabled child, of their disabled siblings' special needs trust, because that can really cause a lot of challenges. Okay. So then if you're not naming somebody that you know, who would you be naming? And there's really two main categories here. There's private professional fiduciaries, who are individuals who do this. They act as trustee. They're licensed through the state of California. Now, you know, the main drawback with a private fiduciary is usually they're about my age or older. Okay, so they probably won't be around for the lifetime of your child. So you'd need to put in some mechanism to name another successor trustee if that private fiduciary is not available anymore. The other option is a bank. There are some banks and trust companies. In fact, I think there's a trust officer from one of these banks on the call right now. And some banks will act as trustee of special needs trusts. Not all banks, but some banks, okay? And just like private fiduciaries, not all private fiduciaries will act as a trustee for a special needs trust, especially for somebody with mental health challenges, but some do, all right? We already mentioned the pooled trust. There's also some nonprofits that act as trustee of special needs trusts, and then sometimes you can combine them. For example, you can have a family member acting as co-trustee with a bank. Usually private fiduciaries will not act as co-trustee with a family member, all right? So then, you know, you might be thinking, well, that sounds kind of good, but what happens if this private fiduciary or the bank is really stingy and they're not making distributions for my child? You know, they want to manage the underlying assets and get paid, but they're not really checking in on my kid. Or even worse, what if they embezzle the money? Like, who's going to be overseeing that? The nice thing about a trust is it doesn't go through the court process. But the drawback is it doesn't go through the court process. So you don't have a judge who's overseeing it. So the way I typically suggest building in oversight for a professional, you know, either a corporate trustee or a private fiduciary, is something called a trust protector, right? This is an individual. This could be the neurotypical sibling. This could be a caring auntie or uncle or niece or nephew, who once a year they check in and they have access to the books and they get accountings and they have the power to remove and replace the trustee with a different trustee. They're not directing how the money should be distributed. They're not getting into the weeds on it because we want to absolve the trustee, the trust protector, of liability. So they're not a fiduciary, but they're kind of the overseer, okay? We used to have something called an advisory committee. That used to be pretty popular, where you'd name, you know, I want this social worker and this uncle and all these people to kind of meet together once a year and discuss how the money should be used and what new treatments are available. But that can get very expensive. So usually we don't recommend that. Okay, so the other thing I think is very important that is separate from the trust is a memo of intent. So this is basically, dear successor trustee, here's all the things I want you to know about my child that, you know, that I've learned over the last 20, 30, 40 years. Here's a big brain dump. This is what makes them happy or sad. These are the meds that they've tried out that have worked, that have not worked. Here's the extended family that I want them to spend time with. That sort of detail doesn't go in the special needs trust. It can go in a separate letter. And let me tell you, successor trustees usually love this information because it's really getting them up to speed on your child, okay? So I always recommend doing a memo of intent. And by the way, you may not know, but I have a YouTube channel. And so after this, feel free to go and look at it. I do have a video on just about everything we discuss here, the memo of intent, the trust protector. They're about 10 minutes long. I think they're pretty digestible. Okay, so now you might say, well, I mean, special needs trust sounds okay, but I don't know if that really works for my child. Or your child might be getting benefits that are not affected by income limitations, like SSDI is not affected by unearned income like dividends. Medicare is not, they don't have income or resource limits. If your child is in that category, you can set up instead a dynasty trust, which I also call a lifetime trust. Now, the big distinction, I think, between a dynasty trust and a special needs trust is the child, if you set it up this way, the child could act as trustee of their own dynasty trust. You could also say they are never to act as trustee, okay? But the dynasty trust provides some really good creditor protection. So if your child gets married and then divorced, everything is segregated and protected for them. If they're sued, there's a high level of protection. And there's also an estate tax protection that I'm not going to dive into, but if you want to learn more, you can look at the video. So that is, I think, a very helpful tool that sometimes I suggest where we really don't need a special needs trust for public benefits purposes. The dynasty trust can be a good protective trust for a child. Okay, so I'm actually going to pause there. And I want to see and open that up to questions before we dive into the ABLE account.
We do have 2 questions in the chat.
Mhm.
The first question is, can you please define resource limit?
Okay, so a resource limit is how much countable assets can you have in the bank? So that's like savings in the bank account. That can be mutual funds. It could be a rental property. There are certain things that are exempt assets that don't count towards that $2,000 resource limit. So it's really how many assets are you allowed to have? And $2,000 is way too low, obviously. There are some proposals in Congress to raise that to $10,000, which is still way too low. But they're saying if you want to qualify for these public benefits, basically you have to be poor. You have to really get rid of your money or spend it down or somehow, you need to be poor, which again, you're not asking my political opinion, but I think it's awful. But that's what a resource limit is. It's how many assets can you have in your own name and still qualify for a certain public benefit.
Thank you, Ellen. The second question is, who is the pooled SNT pooled with?
So you're pooled together with other SNTs. So there's a lot of SNTs that say maybe they're too small, like they have $50,000 and you can't, you don't have a family member to manage it, but you can't find a professional fiduciary who will manage $50,000. So in that time, you can add it, you can, join a pooled trust, which is a lot of little special needs trusts all pooled together.
Thank you.
You bet. Okay. All right, let's dive into ABLE accounts. I love ABLE accounts. I think they're awesome. All right. So basically, this is a savings account for somebody who's disabled. All right. And it's super helpful because remember that $2,000 resource limit that we were talking about, right? SSI, right? You can only have $2,000 in your bank to qualify for SSI. Well, what if your child is earning some money and they want to save up some money to buy, a modified van or to buy a really nice TV or, we're America, we want people to be able to save up their money. So what actually happened was there was a group of parents of children with Down syndrome in Virginia, and they got together and they talked to their representative. And basically there was bilateral, there's support from both sides of the aisle to get this passed. And so it stands for Achieving a Better Life Experience, ABLE account. All right. So it's modeled after a 529 plan. If you're familiar with education savings plans, the ABLE account is called a 529A plan. So basically the idea is post-tax money, after you earn money, you've paid taxes, that money goes into the ABLE account and it can grow and grow and grow. And then as long as it's distributed for qualified disability expenses, which I'll define, it's very broad, you don't have to pay the capital gains tax. Now, there are some limitations, and the main limitation is that you can only put up to $18,000 into an ABLE account per year. And that's not $18,000 from grandma and $18,000 from uncle, $18,000 period. That $18,000 is actually the annual exclusion amount. So last year, it's how much you can gift to somebody and not have to report it to the IRS. All right. So last year it was 17,000. Next year, we're expecting it to go up to 19,000 because of inflation. But right now, that's how much it is. So if you're leaving your child an inheritance of more than $18,000, which I hope you would be able to do, then you can't leave it to an ABLE account, right? Because that can only receive 18,000 a year. But it's a really great savings account. And so I want to kind of describe how it operates. Okay, so to be eligible, the child has to have what's called a qualifying disability. So this means they either are receiving SSI or SSDI, something from the Social Security Administration, or they have a self-serving doctor's note. And I'm going to give you an example of that on the next slide, I think. And here's the other limitation. The beneficiary, the child, their disability must have manifested before age 26. Now, this is very limiting in the mental health community because a lot of people, their disability started at age 30 or 35, right? That's when the symptoms started. But happily, Congress has fixed this. Well, fixed it. They've increased the eligibility age so that as long as your symptoms manifested before age 46, starting in 2026, all right, then you can qualify for an ABLE account. So it's nice that there's some movement on that. Now, you can only use it for qualified disability expenses. I have a slide on that. You only get one ABLE account. So it's not like you can set up an ABLE account in California for your child and then one in Ohio and then one in Utah. No, you just get one. And here's one limitation. If you're putting money into the ABLE account each year and then it goes over $100,000, if your child's receiving SSI, their SSI is suspended. So most people are keeping their accounts below $100,000. However, even if it goes over $100,000, you can continue to receive Medi-Cal. So here's an example of a self-serving doctor's note. So this is something that the doctor would fill out that basically says, this child, has a medical diagnosis or impairment based on my observation, testing, and treatment, and the onset of this condition started before they turned 26. Signed. You don't even have to give this to anybody. This just stays in your records. So just about any, and really ABLE accounts are, well, I hope nobody's on here who deals with, who is part of the ABLE board, but they are not closely scrutinized. So just about everybody who has some sort of disability can qualify. So this is what ABLE accounts can be used for. It's really kind of anything. I mean, you look at this list, right? Education, transportation, anything that you need for your day-to-day lifestyle. So it's really not, it's hardly limited at all. Now, it can't be illegal stuff. It's not supposed to be gambling, but kind of everything else, honestly. Okay, now some people have set up a 529 plan for their child, not knowing that their child would have a disability. And then it turns out their child is disabled and can't go to college and you can't get the money out of a 529 plan. You can actually roll over $18,000 a year from a 529 plan to an ABLE account, right? So it's flexible that way. Also, if you have a child who's working part-time, they can contribute their earned income over the $18,000 as long as they're not participating in a retirement plan for their employer. So that's kind of how they figured out disabled people can save up their money for retirement. So if you add that together, that's about $33,000 that can go into an ABLE account per year if you count your child's if they're earning money. All right, now, so a big restrictive law was passed that California residents basically need to set up CalABLE accounts. If starting last year, if you set up an ABLE account in another state, and most states have established their own ABLE account. If you set one up in another state after January of 2023, then you're going to be penalized because Medi-Cal will be able to bring a reimbursement claim against the ABLE account. So let me back up just a second. The ABLE account was originally created to have a Medi-Cal reimbursement claim just like the first party special needs trust was, okay? But California waived that requirement. So Medi-Cal does not go after ABLE accounts, but then they said, well, hold on, maybe, I don't know, maybe they were thinking this, too many people are setting up ABLE accounts in other states. So let's just make them set up an ABLE account in California. So it's definitely an incentive to only set up an account here in California. So here I've done another comparison chart because I find them helpful. So I'm comparing, when do you use an ABLE account versus a third-party special needs trust? So really, the third-party special needs trust is really intended to receive an inheritance or a large gift. An ABLE account is really meant for smaller amounts of money. Making gifts. If you give $1,000 each year to each of your grandkids, but then your grandson says, hey, don't give that to me, it can interfere with my SSI, that you can give to an ABLE account. That's a really good option to give. You can have several third-party special needs trusts set up. We see that a lot for families who are divorced. Parents who are divorced, they might each set up their own third-party special needs trust for their child. One interesting thing is that an ABLE account can be controlled by the beneficiary themselves if that's the right choice. A lot of times beneficiaries are not a good choice for controlling, but you can do that. And then the Medi-Cal waiver, the California waiver of receiving Medi-Cal is there as long as you set up a Cal ABLE account. Third-party special needs trust does not have does not allow a Medi-Cal reimbursement claim. That's a third-party special needs trust. I'm sorry, a first party. The first party does allow Medi-Cal reimbursement claims, third party does not. Okay, so how much can you put in? So this is the big limitation. ABLE account, you can only put in $18,000 a year, whereas the third-party special needs trust, you can put in as much as you want. The ABLE account counts as the individual's own money. So you can make gifts, even if somebody else is managing the ABLE account. So you can make gifts to it and it qualifies for the annual exclusion and you don't have to report it to the IRS. Third-party special needs trust, you don't get to do that. And then there's a cap if you're receiving SSI. Then I talk about I'm not going to go into the income tax ramifications, but I do have a video. I feel like Elizabeth Warren, who, when she was running for president before, she's like, I got a bill for that. I feel like I have a video for that, and then what kind of distributions can be made. They're both very, very permissive. I think that there is a fallacy out there that special needs trusts are restrictive, and they're not. They can be used for just about anything as long as the trust is drafted that way. Sometimes people draft a special needs trust in a way that it shouldn't be drafted, that says you can't use it for housing, you can't use it for food. No, that's just in very narrow circumstances that could even apply, and it's kind of putting a huge blanket of restriction that doesn't need to happen. Okay, so you're thinking, well, this Cal ABLE account sounds great. Where do I go to set it up? Do I go down to the Wells Fargo or the credit union down the street? No, you go online. This is the only place you can set up a Cal ABLE account is online at calable.ca.gov. All right, so you need the child's social security number and also the social security number of whoever's going to be managing the account if it's not the child. You do have to set up a bank account where the money is housed, okay? So that could be, a checking account somewhere. And then that bank account information is shared with the people behind the scenes at Cal ABLE, which is, that's Vestwell. They're the ones who run the Cal ABLE program now. And they talk to each other. And you can also get a reloadable Visa debit card. That's basically how you get the money out of the Cal ABLE account. Okay, I think I'm gonna pause there and answer some questions. So any questions that came in?
There is one question regarding the resource limits again. Is it true that if you leave property to your child, that would cancel the benefits?
So it depends. A house can be an exempt resource if it's your residence. So if a child inherits a house that they're living in, then that is their one exempt resource. If it's a rental property or they don't live there, then that is a countable resource, and it does count towards the $2,000 resource limit. Okay.
Thank you. That's the only question.
All right. Okay. Let's keep going then. I do want to talk about decision-making just briefly, because a lot of your kids probably don't qualify for a limited conservatorship. So how do you help them to make better decisions? And when you learn that, let me know. I have a 9-year-old and an 11-year-old. And by the way, my 11-year-old has high functioning autism. So I'm also a mom of a child with special needs. But you know, we want to help our kids to make good decisions. So here are the different ways that you can make decisions. You can, you know, you can make decisions for them, which is a conservatorship. But as you know, that's only available, or you may know, that's only available for folks who have developmental disabilities and are members of the regional center. So if you have a child with comorbidities, they have autism and mental health challenges, then they could become a member of the regional center because of the autism diagnosis. But if they only have mental health challenges, they're not going to qualify for the regional center, and they won't qualify for a limited conservatorship. So now you're looking at other options. They can sign a durable power of attorney or advanced healthcare directive. That's called delegated decision-making. They're allowing you to make decisions on their behalf. They can share decision-making with you. And then there's something called supported decision-making. And that's really what I want to focus on. But let me just mention the delegated or shared decision-making. Everybody who's age 18 and up should have a durable power of attorney. Everybody on this call, me, anyone, if you turn 18, you need a durable power of attorney and an advanced healthcare directive, anyone who's not conserved. Okay, then also, if you have a child who has behavioral issues, you can alert the police with a form AB 1424 to really let them know, hey, this is what to watch out for my child, really to protect them from violence from the police, okay? Or, yeah. And then also, if they're receiving Social Security benefits, you can be their rep payee. You can manage the $1,200 a month or whatever they're receiving, you know, per month. Now, one of the drawbacks is that this is voluntary, so your child can decide, I don't want my parent to help me make this decision anymore, or to make the decision, and they can do away with the durable power of attorney. And also, if you're making decisions on their behalf, that doesn't actually train them to make good decisions. So one thing that's developed recently that I think is very important is something called supported decision-making. And this is basically where you put a group of adults that your child trusts around them, and those adults sign a contract saying, hey, these are the areas that the child wants me to support them in. So I have an example that I love to share. So when I went through law school, my dad was a lawyer for many years, and he was the dean of a law school and a law professor. And so I asked him a lot of questions about law school, okay? However, I didn't ask him about dating, all right? I asked my other friends about, you know, getting help in my dating life. So I had different friends who helped advise me about different things, but ultimately I made my own decision. That is what supported decision-making is. You're helping to empower your child to make better decisions by putting adults in their lives who they trust. So it's viewed as a less restricted alternative to conservatorships. And fortunately or not, even children who have a developmental disability, I found in Santa Clara County, the judge, or maybe it's the court investigator, but their team is pushing back against allowing conservatorships because they're saying, well, have you tried supported decision-making before you're just taking away the child's rights? So that's made it more difficult to get conservatorships. So really we're trending more towards supported decision-making. So I have an example here of what one of these agreements looks like. California has not created their own supported decision-making agreement, but this one's from the ACLU, and I think it's very good, okay? And it's really straightforward. So my name is, that's the child. They fill in their own name, and they say, you know, I want to have people I trust to help me make decisions, and they're called supporters. Okay, so the supporters are not making the choices for the child. And I recognize, especially when your child is going through a manic episode or depression or something, they may not make the best decisions, all right? There are healthcare directives that are meant for individuals with mental health challenges, where they can say, hey, if I'm in a locked facility, these are the decisions I want to be made. But this is really helping your child to make better decisions themselves. So they are the decider. They're the ones who make the decisions themselves, and they fill out their information. And then they say, this is one of the supporters. This is one of the people, one of the adults that I want to help support me in making my own decisions. And here are some of the areas that I'd like help with, you know, making safe choices around where I live, choices about my friends. I mean, I wish that kids were more open to, you know, who they are influenced by with their friends, you know, making healthcare choices, choosing about dating, sex, and birth control and marriage, right? Help with money decisions, right? These are all areas that we can all use help with at certain times. Now, supported decision-making has grown a lot in the last 20 or so years, but especially in the last 15. And so you'll see in California, we just passed a statute in 2022. It's very, very recent, and we're still kind of figuring out how does this all work. It actually started, the first state to pass a supported decision-making statute was Texas. All right, so, you know, so there's different states that have implemented supported decision-making, some who have not, and then some who have implemented it just for organ donation, which I find really suspicious, but who am I to say? All right. Oh, that's it. Okay, so I want to pause there and answer any questions about supported decision-making, or I know I didn't dive into limited conservatorships at all because I just don't think it really applies to this group, but I do, again, I have a video on it. So Sophia, any questions that have come up?
Yes, there's two questions in the chat. The first one is, how do I find out if my child's disability is quote unquote qualified?
So you would apply with Social Security Administration, and they'll ask for all the documentation. You know, you can get, there are some people who help with that, some consultants. Really, you want to, this is going to sound horrible, but you want to make your child look as bad as possible. You know, as I think as parents, we want to present our children in a good light, but you have to have documentation of, you know, did they have an IEP? What did it say? You know, were they ever able to work? Could they only work for a week and then they were fired, or they just couldn't make it? So you have to have all of this evidence that really, because when you're looking at being disabled, the question is not, do they have OCD? Do they have, you know, bipolar? The question is, do they have some sort of disability that makes it unable for them to work and support themselves? Okay, what's the, you know, what's the effect of their disability on their ability to support themselves? Okay, so you'd go through the Social Security Administration. Again, they'll probably deny it, right? Only 40%, statistics say 40% of applications for SSI and SSDI are approved, but 50% of the appeals are approved. So just keep trying.
Thank you. The next question is, where can we get a copy of the ACLU supported decision-making contract?
Oh, you can look it up online. That's where I found it. So yeah, just Google it. I think it's terrific. There's a few other ones out there as well. And, you know, I think Texas has their own, but I hope California comes out with one soon. But, you know, it's not, I mean, it's a binding contract in that, you know, people are agreeing to this, but there shouldn't be any liability behind it. If you're an adult who agrees to support a child with disabilities, if that child ends up making a poor decision, it shouldn't be coming back to you. You know, you're just helping them out. So I think that's one thing to keep in mind.
In supported decision-making, do supporters work with the child as a group or individually on different things?
It could be whatever's most helpful for the child. I mean, it's really, there's quite a variety. You know, if the child's open to a group setting, that could be great. It could be one-on-one. You know, also, if your child is conserved, you can still do supported decision-making within the conservatorship label. So whatever works for your child. I think that's what they're trying to accomplish. You know, we want to find ways besides just taking away our children's rights and they can't sign contracts anymore, and you know, which can be pretty demoralizing to a child. You know, instead we want to embolden them and help them to feel more confident in making their decisions.
The last question is, we do have a participant who falls under limited conservatorship. So, and I'm curious too, where can we find your videos about those topics?
Oh, there you go. Well, just here, let me move on. Good segue. Okay, so this is a little bit about us. So we're located in Palo Alto, but we do a lot of our calls over Zoom. So we help people all over California, including Santa Cruz, which, by the way, I would love to move to Santa Cruz someday. So that's kind of my long-term retirement goal. This is where you find us, YouTube. All right, we're on YouTube. Just look up Ellen Cookman Law, and you'll find a lot of videos come up. Please like and subscribe, you know. But if you type in Ellen Cookman Law limited conservatorship, you know, type in the subject, then it should come up. We're also on social media. We're on Facebook and LinkedIn. So if you like those platforms, we do post just about every day. And some of our posts, I think, are, you know, some of them are fun, but some of them are quite relevant to these topics. Okay, and then finally, this is how you can sign up for our newsletter. We do send out a monthly newsletter on, I think, very important topics in that relate to estate planning and special needs planning. If you do the phone thing, you know, you just use your phone and scan that QR code on the photo app. And if you do decide to come in, because we do accept new clients, if you do decide to come in and move forward with flat fee planning, which would, you know, being basically revising your trust or doing a special needs trust, then we would make a $300 donation to NAMI Santa Cruz in gratitude. So I'll leave that up for a second. Yeah.
Thank you so much, Ellen. We do have a few more questions.
Okay, great.
Can a supporter support their child in a court situation or other legal arena if listed on the SDM?
Sure. Yeah, if being listed on the supported decision-making agreement doesn't limit you to doing other things. You know, you can be the conservator of a child, and you could be a supporter on a supported decision-making agreement. So yes, it's quite broad.
If my child owns a car, does that count towards their resource limit?
You get one car. So you get one house and one car. And also if you have retirement accounts, well, if the child has a retirement account and there's a penalty for withdrawing it, usually that's not considered a resource as well, but kind of everything else is.
Good to know. If the parents are divorced, can each of them set up a special needs trust, or is it limited to just one?
You could do either way. Unfortunately, you know, the rate of divorce in the special needs community, and especially with mental health challenges, is very high, as we know. So I have done both. I have represented both parents in creating one special needs trust that the parents fund into. And I've also represented, I've represented one parent who creates a special needs trust, and then the other parent decides to create their own special needs trust. So you can do it either way. I mean, I don't think, I think it might be simpler to have one special needs trust, because then you just get one tax ID number to report, because you do have to report income taxes each year. But what I've done creatively is you can have a special needs trust, and then you can say, okay, you know, let's say it's, you know, John and Jane, right? So John, let's say John puts in 40% of all the money that ends up going into the special needs trust, and Jane puts in 60%. So upon the child's death, 40% of the remaining money goes where John says he wants it to go, and 60% of the remaining money goes where Jane says it should go. So in that way, the parents can still be kind of in control of where their respective money goes, but they do have to agree on who's the successor trustee. You only get one successor trustee or at a time, or co-trustees. So, you know, so if parents can work together, then I suggest doing one. If they can't, then you should do 2. And I do have a video on estate planning or special needs planning during a divorce. So I do talk about that during that video.
Thank you.
You bet.
We have one more question. How much is the flat fee for trust?
So it really depends. It depends on what needs to be done. You know, if you call our office, we're happy to talk you through. We're not actually supposed to kind of, you know, put it on the website or broaden it. It's kind of weird. It's a, what do you call it? They think we're kind of price fixing if we post it. But yeah, please feel free to reach out to our office and we can talk to you more about that.
And thank you so much for that generous offer of making a donation to NAMI for each new client. That means a lot. And while we wait for more questions, I do want to mention that this has been a ton of really detailed and useful information, and I will be sharing both the English and Spanish versions of this slideshow on our website, as well as sending out a follow-up email to everyone here who is registered with Ellen's links to her YouTube channel, any other resources that she's mentioned, so that we can all reference those after we leave this evening. We do have one more question, I see. Can you talk more about not naming siblings as trustees for Special Needs Trust? Who else knows them well enough? We are just completing our Special Needs Trust and have named our adult siblings. Can you talk more about the reasons why not to do that?
Yeah, so I mean, it really depends on your child and on their relationship with their siblings. Okay, so sometimes it works. You know, if you have a child who's quite cooperative and gets along very well with their sibling, then I'd say, you know, you can go for it. I think the challenge we get is sometimes we have these rose-colored glasses and we think when we're gone, our kids will get along better. And I don't know why we think that, because it actually gets worse. You know, you don't have the parent there to, you know, to make sure that kids get along and to mediate fights or moderate fights. So, you know, the role of being a trustee is quite loaded. I do have a video on trustee roles and responsibilities. There's a lot you need to do every year. And if the special needs child has any problems, they're going to call the trustee, and they might call them 10 times a day, you know. And so is that really the role that you want the neurotypical sibling to be in? You know, the neurotypical sibling might want to travel or, you know, do other things, or they're busy raising their own kids. So it's a big burden to make your child the surrogate financial parent for their sibling. And so that's why I usually recommend not doing it. But again, it really is case specific. So you look at your specific family needs. Instead, you can name a professional and name the neurotypical child as trust protector. So that's really, you know, the other alternative that I've seen families turn towards.
Thank you for that insight. Can you please explain a little bit about the advantage of having a special needs trust with respect to probate, and what is the probate process?
Okay. So probate is really when you own stuff and it's in your name and then you die. And we don't know where it goes because it's just in your name. So then you have to go through a court process, and you know, and then there's a set of rules in the probate code that says, okay, who inherits your money if it's not in a trust, if you don't say where should it go. If you have a trust, that avoids probate, because in the trust it says where should the money go, who's going to manage the money, who's the successor trustee. It's you're lining everything up, and courts really love trusts because they don't want to do probates. Probates are expensive, they're time consuming, they're public. You know, people can find out about where your house was, and then they might try to break into the house. We've gotten a lot of solicitations from people. You know, we used to do probates. I hate them so much, I don't do them anymore. You get paid a lot as an attorney to do a probate. So if somebody has, let's say somebody has $1 million bank account held, you know, at Morgan Stanley, and it's just in their name, and then they die. Well, you might think, well, of course it goes to their kids. But how do we know if those are their kids, right? So there's a judge that oversees the process of things going from that person as an individual to their kids. Now, If some money is in a revocable trust or in a special needs trust, the trust details where the money goes and who's managing it. So you don't need the probate court system. So you avoid probate. So everybody here most likely needs a revocable trust. And in your revocable trust, that holds your stuff. And it says, upon my death, everything goes equally to my kids, but the portion for Joey goes to his special needs trust. And then when you die, the successor trustee that you've named for your revocable trust oversees that process and makes sure that everything goes equally to your kids and Joey's portion to his special needs trust. And then the trustee for Joey's special needs trust steps up and starts managing Joey's special needs trust. And then when Joey dies, the special needs trust says where it goes. So nowhere in that process do we need the probate court because the trusts spell out where everything goes.
Thank you.
Sure.
There are no more questions in the chat. We do have this meeting open until 7:30, and people are welcome to use the raise hand feature, put a question in the chat.
Wonderful. Well, I can sign off and let you guys do your thing, if that's okay.
We do have a few more questions, actually.
Oh, okay.
People took my hint.
Yeah.
How do you suggest leaving a home to your children when one has a mental health or substance abuse currently, but unsure if it will change in the future? Is there an option other than forcing the sale of the home?
That's really hard, especially if your home is your main asset. Because you can leave your home, if you have a couple of children, you can leave your home, half to the neurotypical child and then half to the special needs child. And then if the special needs child ends up living in the home, then they can pay rent to the neurotypical child. However, in California, we have this thing called right of partition. So that means if you own even like 1% or 5% of a house, you have the right to go to court to sell the house. So, so you need to make sure that both your kids are on board for whatever your plan might be. And the special needs child may not want to live in the house, so there's a lot to consider. So I don't have like a straightforward answer for you. It really depends on the particular situation that you're in.
Thank you. Do you get the tax ID for the trust ahead of time?
So for a revocable trust, you don't need a tax ID number. You just use your social security number. For a special needs trust, I usually don't get the tax ID number until it's ready to be funded. And while you're alive, you are the special needs trust. You're providing everything that your child might need, okay? There's no reason really to fund this, to put money into the special needs trust. That's what we call it. We call it funding a trust. That's when you actually put stuff into the trust. There's no reason to fund the trust while you're still alive. And then once you fund it, then you have to keep accountings, you have to file a separate, then at that point, you have to get a separate tax ID number and file income taxes, which is really a pain if you don't have to do it. So usually I recommend setting up what we call a seed trust, SEED. So that's a trust where you already see the structure of the trust, and we say it has like $10 in it or $100 in it. So it's not enough money in it to need to get a tax ID number. We really don't. It's some people that used to make a photocopy of a $10 bill and attach it to the back of the trust. We don't do that anymore. Nobody's really asking, where's this money? But it's just a tiny little bit of money that sets up, that establishes the structure of the trust. So it's really an open basket that's waiting for somebody to die or to make a significant gift to the special needs trust. So no, I wouldn't get a tax ID number immediately. You wait until the trust, it's time to fund the trust, until money is about to go into the trust.
Great. And I did get a question about your YouTube channel, so I put a link in the chat for anyone who's curious. Click on that link and it is a trove of really helpful information. All right, that's all the questions. We do have some people saying thank you. This has been very helpful, and I would like to repeat that. Ellen, thank you so much. This has been extremely helpful, a lot of really useful information and really relevant to our participants. So we appreciate you having spending your time here with us tonight.
You bet. It's been my pleasure. Thank you.